In this video, I'll be discussing active financial collections, or AFL collections. Hi, I'm consumer protection attorney Bill Clanton. I've helped hundreds of consumers, regular folks, deal with debt collection harassment, inaccurate credit reporting, and other consumer-related matters. At the end of this video, you'll understand who active financial is and what laws protect you from their bad behavior. Active Financial Collections is a third-party debt collector based in San Diego, California. My research shows they were formed around 2011, and they're not a contingent collector and they're not a debt buyer. They just collect debts. They serve a variety of industries, including auto debts, medical debts, discharged credit card debts, basically just a wide variety of debts that they collect. They've been sued, according to federal court records, about 10 times for violations of the Fair Debt Collection Practices Act, or FDCPA. They've got at least 3 Better Business Bureau complaints and at least 5 Consumer Financial Protection Bureau complaints. So Active Financial Collections they're a third-party debt collector, and they're fairly aggressive. Not being a contingent debt collector means that they get paid whether or not they actually collect a debt. These types of debt collectors tend to be less aggressive than some of the contingent debt collection outfits. There are 3 powerful laws that protect you from active financial: the Fair Debt Collection Practices Act, the Telephone Consumer Protection Act, and the Fair Credit Reporting Act. Now, most of the suits I've found against active are under the Fair Debt Collection Practices Act, so I'll talk about it first. The Fair Debt Collection Practices Act was passed in the late 70s to protect consumers, regular folks, against debt collectors. The Congress found there was abuse and harassment and threats that were untrue and unwelcome, that were causing people to lose jobs, file bankruptcies, and interfering with people's marriages. So they enacted the FDCPA. The FDCPA says that active financial cannot disclose your debt to a third party. They cannot threaten you with actions with physical harm, first of all, or they cannot threaten you with actions they don't intend to take or that they cannot legally take. They cannot make misrepresentations to you about the debt, especially about the amount or the character or the legal status of the debt. If they're reporting it on your credit, they have to report it accurately. And if you dispute it, they have to report it as disputed. If they're calling you on the phone, they cannot call you before 9 a.m. or after 8 p.m. They can't add amounts to the debt that were not provided for in the original contract. They can't just add collection fees or other costs to the debt. Now, at the outset of the collection activity by active financial, they have to give you certain disclosures. Now, it has to come as part of the first communication or within 5 days of the first communication with you. These disclosures include the amount of the debt, the current creditor the debt is owed to, and they have to inform you about your right to dispute the debt, request verification of the debt, and to request the name of the original creditor if it's different than the current creditor. Now, you can dispute the debt at any time, and you can do that over the phone or in writing or however you like. But requesting verification and asking for the name of the original creditor have to be done within 30 days of receiving this letter, and they have to be done in writing. Now, the language in these disclosures has to be correct and has to follow the law. There's a lot of lawsuits filed over the language in these letters and follow-up letters that you may be getting from Active Financial. So save any writings that you get or any emails that you get from Active Financial. Another law that applies to Active Financial is the Telephone Consumer Protection Act, or the TCPA. If Active Financial calls you on your cell phone using an auto dialer, then they have to have your permission. If they don't have your permission, then that call is a violation of the Telephone Consumer Protection Act. You can revoke your permission at any time. Now, the Telephone Consumer Protection Act has significant penalties. For a call to your cell phone without your permission, the penalty is $500 per call. If you can show that call is made knowingly or willfully, then you can get up to 3 times that amount, or up to $1,500 per call. An auto dialer can place thousands of calls every hour. The damages in a Telephone Consumer Protection Act case can add up very quickly. The third law is the Fair Credit Reporting Act. If Active Financial is going to report on your credit report, then they have to do so completely and accurately. If their reporting is inaccurate, you have the right to dispute it with the credit bureaus and with Active Financial directly. Once they receive the dispute, they have to do an investigation. If after the investigation they do not correct the information, then you can file a lawsuit against Active Financial for the harm they've caused you with their inaccurate credit reporting. Dealing with debt collectors, not any fun. And I want to help you out. These 3 laws can turn the tables on Active Financial. I want to put them to use for you. I don't charge anything to work on these cases. I only get paid at the end of the case when I make a recovery for you. I won't charge you anything to evaluate your case or to get started on your case. So you've got nothing to lose. Give us a call today. The number here is 210-226-0800. Thanks for watching.